Thank you. Hello, everybody. Good afternoon. Welcome to our webinar today. It is Will Taylor Swift Need a Prenup? The Nuts and Bolts of Celebrity Prenups. I am Keith Cooper. I am Secretary of the Beverly Hills Bar Association's Entertainment Law Section. I am here today to introduce you to a family law specialist and an expert, Monica Mazzei. Monica is a shareholder at Buchalter San Francisco office, and she's the chair of the firm's family law group. She is a certified family law specialist. That's an important distinction. She represents high net worth individuals. She represents clients throughout California and her practice area is mainly in San Francisco and the Silicon Valley, as well as here in Los Angeles. For over 2 decades, Monica has specialized in dissolution actions involving complicated valuation and financial matters, complex community property, support issues, and international issues as well, marital dissolutions, including those involving hedge funds, private equity, venture capital, and privately held businesses. She also drafts and negotiates cohabitation agreements, premarital and postmarital agreements. She is a very accomplished speaker. I wanted to just call out a couple of things because she's received many awards and accolades. It's important to note because you are getting high-level expertise here. Monica was Vogue magazine's influential woman star of a woman of San Francisco, top women attorneys in Northern California from the American Registry, one of the 10 best attorneys in California from the American Institute of Family Law Attorneys, top 40 family lawyers under 40 in California from the American Society of Legal Advocates, and the top 40 national trial lawyers under 40. There are many, many more, but in the interest of time, I'm going to stop there and I'm going to introduce Monica. Welcome to the program, and thank you for doing this program today. We appreciate it.
Well, thank you for having me. This is my favorite topic to talk about, our premarital agreements. And many people say, does Taylor Swift need a prenup? Well, of course she does. But you would be surprised at how many celebrities and high net worth people that don't have a premarital agreement. It might shock you to know that reportedly Justin Bieber doesn't have a prenup. So after you listen to this presentation today, you will know all the reasons why you need to tell your clients that they should probably get a prenup if they're thinking about getting married, especially if they are a celebrity client. So I'm going to go to the first slide. What a prenup can do and not do in California. So that's dictated by Family Code Section 1612. And I'm not going to go through and read the statute, but I'll summarize for you what it can do. So in California, clients can contract in a premarital agreement about anything financial. The only things that they cannot contract around are child custody and child support. So the state of California says that child custody and child support are rights that belong to children, and the parents are not able to contract those away or restrict those. However, everything else is game. So clients are able to determine in a premarital agreement characterization of assets. Are they going to be community? Are they going to be separate? Or are they going to be somewhere in between? 40% community and 60% separate. Clients can also contract around spousal support. So there can be a complete waiver of spousal support in a premarital agreement, or there can be a predetermination of what spousal support will be in the event of a divorce. And a premarital agreement can also address, although it doesn't have to, what would happen in the event the clients are happily married, what one person predeceases the other. They have an estate planning provision in the premarital agreement, although it doesn't have to. So the main purpose of the premarital agreement is to predetermine what's going to happen in the event of a divorce. A requirement of a premarital agreement in California is that both clients exchange financial information. It looks like a balance sheet or a financial statement, and that's a document that's going to be attached to the premarital agreement. Next slide. A premarital agreement also allows people to decide what law is going to govern their premarital agreement. So for most of the agreements that I do, California law is going to govern the agreement. That means no matter where the clients move, whether it's outside of the state of California or outside of the country, if there's ever an issue regarding the premarital agreement or a contest regarding its validity, the trier of fact in whatever jurisdiction those clients are living in will apply California law to determine if the agreement is valid. So the bottom line is premarital agreements do have a lot of flexibility in terms of clients being able to contract around financial issues related to their marriage, divorce, assets. Next slide. So the types of assets, when we're looking at celebrity clients, we're really dealing with a unique set of assets that are going to have to be addressed in a premarital agreement. So the most typical assets that we think of when you think of a celebrity are intellectual property, or the assets that's most attributable to their fame, patents, copyrights, trademarks, music catalogs, manuscripts. Name, image, and likeness, that's an asset. Livy Dunn, who is an American gymnast, she has a name, image, and likeness valuation of $4 million. That is an asset. Her name, image, and likeness is an asset. And especially when we see professional athletes, there's usually a valuation, associated with the asset. I would say over the last 2 decades, if not the last 10 years, celebrities' portfolios are now beyond what they're kind of known to be famous for. For instance, a lot of celebrities are going to have really significant real estate holdings. Taylor Swift, in fact, has 150 million in real estate assets. Beyonce and Jay-Z have 2 in real estate assets. Art. We see a lot of celebrity clientele with really extensive art collections. Elton John, Steve Martin, Steven Spielberg have a really valuable art collection. Private investments. We're seeing more and more celebrities in the venture capital space. Serena Williams, Nas, Kim Kardashian, who have started venture capital firms making investments in different and startups. And businesses. I think that's what a lot of celebrity and professional athletes assets that they have is a Jessica Alba, who is an actress, started Honest Company that's now valued at $358 million. We had George Clooney, the actor, who started Casamigos Tequila Company, which sold for $1 billion. And the singer Rihanna has Fenty Beauty that's valued at $2.8 billion. So arguably, a lot of these celebrities, the most valuable asset on their balance sheet may have nothing to do with their singing or acting career, but in a lot of cases, it's going to be their business interests. Next slide. Characterization of assets. How do we know if an asset is community or separate? So the default law in California is that an assets that acquired or created during marriage is community property. That means in the event of a divorce, that asset is going to be split 50-50. An asset owned before marriage is separate property. However, the appreciation on that separate property asset may or may not be separate property. So if I own a business before marriage, the business clearly exists before marriage, I've started it, it's my separate property business. However, if I get married and I don't have a premarital agreement, and there's an appreciated value during marriage of my business due to my own personal efforts, I'm running the business, I'm the CEO, the community could very well have an interest in the appreciated value during marriage if I don't have a premarital agreement that says something otherwise. So for example, when we're looking at Jessica Alba's Honest Company, if she had started that company before marriage, it's clearly her separate, it existed. But until recently, she was the chief creative officer. She just stepped down in 2024. So As chief creative officer, she's obviously expending personal efforts, during the marriage, on the business, running the business, contributing to its increase in appreciation. And if she doesn't have a premarital agreement otherwise, all of that appreciation during marriage is going to be community property. So it becomes really important to celebrities, most of which now have these really substantial business interests that a lot of times are their most lucrative asset, to have a premarital agreement to address this. And a marital agreement could say, we're going to adopt the default. It's fine if the appreciation is going to be a community. Or it could say, we're going to opt out. It's all going to be the business owner, celebrity client separate property. Or it could say something in the middle. The agreement could provide that, 20% of the appreciated value is going to be community. That would give 10% to the non-celebrity spouse. So, there's a lot of options here, but I think the point is to ask the question and to know enough, to inform the client that this could be an issue, and it's something that they very well might want to address now so that there's some clarity later in the event of a divorce. I also wanted to give another example, and it's not a celebrity client, but it's a client that came to me about 18 years ago, and she was about 29 years old at the time, and she didn't have any assets, but she had an idea for a business, and she had just gotten the idea started, just started building the business, but it wasn't worth anything. I think she had one car, and that was it. Admit that she wanted a premarital agreement going into her marriage and that she wanted her business to be her separate property. Well, about 6 or 7 years later, I was in the airport and she was on the cover of Forbes, and her business was being valued, in the hundreds of millions of dollars. So also keep in mind that, some client may have an idea, may have just started a business, and it may not be lucrative on paper yet, but it may be worth protecting. Next slide. Earnings during marriage. The default law in California is that earnings during marriage are community property. If it's earned during marriage, it's community. And in the event of a divorce, any accumulated earnings that haven't been spent are going to be split 50-50. Earnings include, of course, cash, but they also include equity compensation like stock and stock options, carried interest, deferred compensation that's earned during the marriage. Basically, any sort of form of compensation is going to be, if it's earned during marriage, is going to be community property. So again, clients can decide, are we going to adopt the default? Are we going to opt out of it and say that earnings are the separate property of the earner spouse? Or are we going to agree to something in the middle, some percentage being community and some percentage being separate? Carried interest is a really interesting form of compensation, and we're seeing it more apply to the celebrity client because a lot of celebrity clients are getting into the venture capital space. So carried interest is a form of compensation in venture capital, private equity, and hedge fund. It's an allocation of profit to the partners in the firm. So it is a form of compensation, and it will be community or in part community, depending on whether it's vested or not, unless you have an agreement otherwise. And again, we've got a lot of celebrities getting in. Kim Kardashian, Nas, Serena Williams. There's a lot of celebrities getting into this space, and they're receiving that form of compensation, which is carried. So it's important that they have an agreement that addresses it, whether they're going to adopt the default or say that it's separate or decide to do something completely different with it. Equity compensation is also something that we're seeing more and more with the celebrity client. So instead of taking cash for a performance or an endorsement, they're taking equity in that company. In 2015, Beyonce took equity in Uber rather than cash for performing at their corporate event in Vegas. So that Uber stock that she earned in 2015 for her performance, unless she has a premarital agreement, that's going to be community property. And if the stock has appreciated, that's all going to be community, and in the event of a divorce, would be split 50-50. Deferred compensation. So if deferred compensation is earned during the marriage, it's going to be community, even if it's paid out after a divorce. So we have the baseball player Ohtani, who deferred $680 million with the LA Dodgers. That's going to be paid out over a 10-year period. He is married. So if he were to, let's say, divorce next year, that $680 million, even though it's paid out over 10 years, half of that is going to go to his wife if he doesn't have a prenup in place. Next slide. Spousal support. I get a lot of questions about this and whether clients can contract around spousal support in California, and whether it's enforceable. Going back to the family code that was on slide 1, yes, if done correctly, clients can contract around spousal support in their premarital agreement, and if it's done correctly, it will be enforceable in the event of a divorce. When is a waiver of spousal support appropriate? So this would be a premarital. In the event of a divorce, neither party is paying the other any spousal support. When you have two celebrities in a marriage, or two high net worth, where a waiver of support is appropriate, perhaps like a Angelina Jolie, Brad Pitt union, or a Kim Kardashian, Kanye West. When you have two wealthy people who have significant assets of their own, that could very well be completely appropriate to have in an agreement that neither is going to pay spousal support to the other in the event of a divorce. What I'm seeing a lot in celebrity prenups and high net worth prenups is a waiver of spousal support, and in lieu of that, a lump sum payment provision. So the agreement would say that if we get divorced, we're both going to waive spousal support, but the wealthier spouse is going to agree to pay a lump sum amount to the other spouse. And it's usually an amount of money that increases over time. For example, if there's a divorce between year 1 and 5 of the marriage, it's X amount. If there's a divorce between year 6 and 10, that amount's going to increase. Year 10 and 15 increases, and so on. The amount that's paid to the recipient is tax-free to the recipient. So the person receiving the money does not pay any tax on that. And the advantage to the payor is, one is to have some certainty, so that they are not paying people like me a lot of money. Spousal support is going to be, and they can predetermine the amounts that they think are fair, as the duration of the marriage, increases. So this kind of provision is for a high net worth or celebrity client that has enough liquidity on their balance sheet to commit to making this payment in the event of a divorce. So this is not a provision that all clients can have in their premarital agreement, because it does take being able to commit to pay this amount, usually in cash, in the event that there is a divorce. A lot of people are surprised that in California, we actually don't have a formula to determine permanent spousal support. So many states in the US will have a formula to determine what permanent spousal support is going to be. In California, we have these 13 factors that range from the age of the parties to their health, to earning capacity, how long the marriage is, all of these factors that the judge is supposed to take into consideration. And because of that, we have really inconsistent spousal support outcomes that can depend on what part of the state you live in, or what judge you have deciding. We don't have a lot of certainty in California around spousal support. So another option, if someone can't agree to make a lump sum payment, is to at least put in a formula to determine what spousal support will be in the event of a divorce. One formula is listed here on the PowerPoint. 30% of the payor's net monthly income less 50% of the payee's net monthly income. And of course, you have to define what income's going to be. Is it capital gains? It's of course going to be wages and compensation, investment income. But it's another way to at least have some certainty in the agreement, and not leaving the clients, to have to figure out spousal support under those 13, factors that really don't provide a lot of guidance. Another option is to be silent. The premarital agreement doesn't have to address spousal support, and that will just be decided if and when there was a divorce. That's my least favorite option. I don't like to draft agreements that are silent on spousal support, because spousal support is one of the most litigated issues in a divorce. And so I think the purpose of a premarital agreement is to provide a roadmap of how to financially disentangle people in their divorce, in a way that they're not spending lots of attorney's fees and 2 or 3 years of their life trying to do. So I personally don't like to kick the can down the road and leave them to determine spousal support later. I like to provide something in the agreement, whether it's just a form to be applied later. The agreement can also address the duration of support. So, is someone going to pay support for every year of the marriage or half the length of the marriage? So the provision can also deal with how long someone's going to be paid support if they're going to be paying a monthly amount. Now, California will enforce these spousal support provisions unless they find that they're unconscionable at the time of enforcement. And this rule comes out of a case with Barry Bonds, the famous baseball player. In the Barry Bonds case, Barry and his fiancée signed a premarital agreement that had a waiver of spousal support. English was not his wife's first language. He had an attorney, she didn't. And there was a huge disparity in income and wealth between Barry Bonds and his wife. Fast forward a few years and they're getting a divorce, and the court found that that spousal support waiver would be unconscionable if it were to be enforced in the event of that divorce. So that's a situation where a spousal support waiver was clearly not appropriate, and the better drafted agreements now would never have a provision like that, waiving spousal support with that huge disparity in income and assets. Oh, next slide. Estate planning provision. Often think of a premarital agreement as addressing what happens if there is a divorce, but they can also address what happens if the clients are happily married, person predeceases the other. So there can be a promise in the premarital agreement that one client's estate plan is going to provide for something specific to the other person in the case that they pass away. Not all premarital agreements will have any estate planning provisions, but when you're dealing with high net worth and celebrity clients, this is often going to be included, because the person coming into the marriage with less will likely raise this and will likely want some assurance in the premarital agreement that if the other person passes away, they will be left something, whether it's the family home or money outright or a trust. And so when we're looking at celebrity prenups, this is definitely a provision that you would expect to see. Mainly a request from the less wealthy spouse coming into the marriage, wanting something specific in the premarital agreement. But the premarital agreement does not have to always include provision. Next slide. Mandatory mediation or private judge. In family law, 2 clients can agree to take their divorce issues to a private mediator, or they can also agree to take their divorce issues to a private judge. So a private judge is typically someone who was a sitting judge in the Superior Court and now has retired, and you can hire them, pay them an hourly rate, and they could serve as a private judge, which means that any hearings typically take place on Zoom or in a conference room, and very few documents have to be filed in the public record. So this would also mean that the client's settlement agreement would not have to be filed in the public record as well. This is a very common provision that you're going to see with high net worth clients and celebrity clients in their premarital agreement. They obviously have a lot of privacy concerns. They don't want their divorce to be in the public record or as possible. So you'll often see a provision that says if there's any issues arise with respect to the premarital agreement, someone's challenging its enforcement, or there's a specific issue related to, some certain aspect of the premarital agreement that needs to be adjudicated, that the clients will go to mandatory private mediation or will hire a private judge, meaning if they can't agree and work it out, they're going to hire a private judge who will decide for them. But again, it's very confidential, very discreet. Most high net worth and celebrity clients are going to have this provision in their premarital agreement. Things are also resolved a lot faster this way. As a lot of you know, the public courts are very backed up, and having a private judge, who you are paying to attend meetings and Zooms and conferences and hearings, things tend to move along a lot faster. Also, the clients would have to mutually agree on who the mediator or who the private judge is going to be, so it gives some control to the in terms of who's going to be, hearing their disputes, as opposed to being in public court and having, whatever judge you are assigned to, for your case. You also get to choose the location of the mediator or the private judge. So in a lot of the agreements that I'm preparing, the parties are pre-agreeing to a private mediator in California, a private judge in California. That means that if they happen to move outside the state or even outside the country at a later time, if there's ever an issue that arises in their divorce, any issue regarding the validity of the premarital agreement, they are going to choose someone located in California to adjudicate that. There is a question as to whether a provision like this could be enforceable if challenged, related to child support and child custody provisions, meaning if someone had an issue regarding child custody, would they be forced to use the private judge as opposed to the public court if they didn't want to go to the private judge? And there's some question about the enforceability of that. So that would be something important for the client to know. But still, this is a huge advantage to a high net worth, a celebrity client, to have a provision like this in their premarital agreement, because at least it will keep marital agreement and most of their financial information as private as possible. Next slide. Confidentiality. This is a provision you're going to see in all high net worth and celebrity premarital agreements. A confidentiality provision will say that the financial information that's been disclosed during the process and the terms of the premarital agreement are going to be confidential. That's a pretty standard confidentiality provision. More and more, we're seeing social media provisions in these agreements that either restrict what can be posted on social media during the marriage, or at least after the marriage, restricting posting of, photos or, private information. And of course, a restriction in the event of a divorce to make comment to the media or the public about the premarital agreement or the divorce. But social media provisions are becoming more and more common, especially with younger high net worth and younger celebrity clientele where, they live out their lives on social media or, posting a compromising photo or video on social media could be dangerous. So those are provisions that, now are kind of getting to be pretty standard in celebrity premarital agreements. Next slide. So Taylor's prenup. If she, what are the kind of assets that Taylor has that she's going to have to think about addressing in her premarital agreement? So her music catalog. So she has an existing music catalog of music that she's recorded. That's obviously her separate property because she's already created it. It's already copyrighted. However, after marriage, if she enters into contracts regarding her existing music, like licensing agreements and streaming deals, unless she has a premarital agreement, otherwise, those new contracts are going to be community property. The compensation that she's getting out of those new deals is going to be community. So she's going to have to think about what she wants to do with those. And of course, her new music. So again, the default law in California is anything that you marriage is community property. That means all music that she writes and doesn't record. That means all music that she records during marriage being community property. So she would have to address whether that's going to be community or separate. Her name, image, and likeness. If she doesn't have a premarital agreement and she gets married and there's a divorce later, there's likely going to be the question of what was the value of her name, image, and likeness at the date of marriage, and what is the value of her name, image, and likeness at the date of separation. And if that value has increased, the question is, does the community get to share in that? The answer is maybe, but if I were Taylor Swift, I don't think I would want to leave that to chance, but I would rather want to address that now and have that figured out. In addition to, her music and her name, image, and likeness, she has her tours. The Eras Tour, her most recent, generated $4.1 billion in total, and Taylor herself earned $14 million per show. So, we're talking about a lot of money. So she's touring after marriage and she's earning $14 million a show. Remember, earnings during marriage are community property. And if she agreement otherwise, those earnings per show are going to be community. We talked about business interests and that becoming a huge part of any celebrity portfolio. And Taylor, like most, has that on her balance sheet as well. She has merchandise sales. In 2023 alone, they were 132 million. So we're talking huge numbers. She also has a company. It's called Taylor Swift Productions, and she's the CEO. And as we talked about earlier, the business exists before the date of marriage, so it's her separate property. But she is the CEO, so she is actively involved in the business. And if the value of that business increases during the marriage, the community may have an interest in that appreciation. So as you see, we're talking about really, really large dollar amounts here that could be attributed to the community, and why it makes sense to have a premarital agreement, at the very least, to address what's going to be community and what's going to be separate. These are really, really large numbers, and for a lot of celebrities and a lot of professional athletes, they're going to be, and it's worth to take the time to put together a premarital agreement and go through these and ask, what does the client want to do with all these different types of assets, and what do they think is fair? And what is their agreement going to look like? Because if they don't have an agreement, in the event of a divorce, we're going to be going through and we're going to be asking, what music did she write during the marriage? Does she have notes of the lyrics she wrote? If she records that later, 10 years after the divorce, does the community get to share in any of that revenue because she wrote it during the marriage? They're very fact-intensive, very expensive inquiries. And having a premarital agreement can solve a lot of that by predetermining what happened. So again, they're not spending, a couple years and a lot of money trying to figure that out. I would say the typical high net worth divorce is about 24 months. And that for a celebrity, that is true, if not more. These are complicated assets. They have many different revenue streams, many different ways of creating community and separate property. And so, these agreements are really key. It's really shocking. I have come across some celebrities. Again, we talked about Justin Bieber reportedly not having a prenup, but he is not the only one. I've come across some other celebrities that don't as well. And it always surprises me. I really think of premarital agreements as almost financial planning. And it would be smart for anyone with significant assets to have this type of agreement. A lot of people ask me, what are the requirements to have a valid premarital agreement in California? Well, we know from the Barry Bonds case that each person has to have independent representation. So they have to have their own attorney. Each person is going to be represented by their own counsel. They each are going to have to exchange their financial information, basically their assets and their liabilities. Typically, that takes the form of a financial statement or a balance, lists everything out with approximate values for high net worth clients, celebrity clients. Those balance sheets can be more than a couple pages. And those balance sheets actually get attached to the premarital agreement, which is why we have this confidentiality provision in the agreement, because it is a very sensitive document. It's going to have all of the client's assets and liabilities in it. It's not a document that is filed with the court. This is an agreement that the attorney will keep at their office and that the client will keep electronically or have a copy in a safe deposit box or somewhere else, but contains very sensitive financial information. In California, the final version of the agreement has to sit for 7 days before it can be signed. So the clients can sign the wedding as long as the preceding 7 days, the agreement sat and there were no changes made to it. So we are on somewhat of a timetable, and there has to be enough time so that we have a final version that remains untouched and unchanged for 7 days before it's signed. For high net worth and celebrity clients, we often start working on these agreements about 6 months in advance of the wedding date. That definitely happens on a lesser timeline, but 6 months would be ideal. As you can see, there's a lot of assets to address. There's a lot of questions to ask. There's a lot of negotiation back and forth. So we want to make sure the clients have enough time to do that. So if you have any clients that you're advising or they're thinking about getting married, you're going to want to tell them that allowing for 6 months is probably the best practice. Next slide. So Taylor's prenup, what would it look like? Well, this is kind of what I envision what her prenup will look like based on my experience of drafting these. I would expect that a prenup for Taylor would say that all of her assets that she date of marriage are going to be confirmed to her as her separate property, including any appreciation on those assets during the marriage. For instance, her production company, that's her separate, and if it increases in value, that's also that appreciation is also going to be her separate property. I would expect that her prenup is going to say that all assets that she creates during marriage are her separate property. That means any music that she creates or writes are her separate property. Essentially, I think that her prenup would not organically create any community property. Basically, everything is going to be her separate property. Her name, image, and likeness is her separate property. Maybe the family residence would be community property. Often the home that the clients spend the most time in is what we call their family residence. And a lot of times the less wealthy spouse may that at least the home be community property either at the onset or become community property at some point during the marriage. So the agreement have a carve out for some certain community property, most likely the home that they spend the most time in. But I would really expect that her prenup would confirm that all of everything that she creates and acquires during marriage is going to be her separate property. I would also assume that there would be a spousal support waiver because there's going to be a lump sum payment provision. So I would expect that with someone like Taylor's balance sheet, where she has definitely sufficient liquidity to commit to make, lump sum payments, that there would be a schedule of predetermined payments that would be made to the less wealthy spouse in the event of a divorce. So that payment has to be a number that is large enough to reflect that the less wealthy spouse is not only waiving their right to spousal support, but they're also waiving their right to potential community interest in all these assets that she creates during the marriage. Her touring, her contracts entered into during marriage, music that she writes and records during marriage. So we're not talking about an insignificant number. I think that the number, would be substantial, but it would still be in Taylor's best interest to have this provision because, again, she could be rest assured that anything that she creates or acquires during the marriage is going to be her separate property. That in the event of a divorce, they're not going to have a messy divorce trying to determine what's community and what's separate and fighting over copyrights and when songs were written. This lump sum payment gives her assurance that she can write a check and they could go their separate ways, and it's a cleaner financial break. And to the recipient, it's also very attractive to get a lump sum payment. Again, it's tax-free. We work in this tax-free bubble in the divorce world where the IRS lets us make payments from one spouse to the other without any tax input. So they're not taxed on their lump sum payment. They're getting all their money up front. They're not getting doled out a monthly spousal support number. So they're getting a good amount of principal up front that they can take and use part of, buy a home or buy real estate or start their own business. So the lump sum provision in these situations is actually very advantageous to both sides. I would certainly expect that Taylor's going to have a confidentiality provision in her agreement. I would also expect there to be social media provisions, maybe not restricting on what's posted during the marriage, but definitely a provision that restricts what can be posted after divorce, probably saying that nothing can be posted after divorce, private photos, videos, letters to one another, text messages, things of that nature. I would expect there to be a provision that they will not speak to the media, about their divorce. I would expect that there's a provision that they will mutually agree on a private judge to adjudicate any disputes that may come up about the validity of the agreement in the event of a divorce, that they're going to choose the location of that private judge, and that to keep as much of the personal information as confidential as they can. I would expect in a prenup like this that the less wealthy spouse is going to bring up having an estate planning provision. Again, a prenup does not have to address what happens in the event that one person predeceases the other. But I would expect that this would be an important provision for the person that's marrying Taylor, and that they would want to know specifically what her estate plan is going to be providing for them. And that could be anything from promising a certain percentage of their estate to their surviving spouse. It could be promising certain real estate, or at least the home that they live in, to their other spouse. And that could be something that's gifted outright. It could be something that is put in a trust for the other spouse. There's a lot of different estate planning tools to use for that. But these are the types of provisions that I'm seeing in high net worth agreements, celebrity, premarital agreement. So essentially not a lot of buildup of community property, separate property belonging, to the creator, to the business owner spouse, a waiver of support, and in lieu of that, these lump sum payments that are substantial enough to address everything that the community is waiving. You also want to make sure that the amounts are substantial enough that you're not incentivizing the less wealthy spouse to contest the agreement, right? You want the agreement to be balanced. You ultimately want the agreement not only to be enforceable, but you don't want to invite a challenge to the agreement. So you want them to be healthy numbers that incentivize the less wealthy spouse to take the lump sum, to not challenge the agreement. I don't see agreements anymore that are like the Barry Bonds agreement, that are just completely one-sided. Nowadays, I don't think we would see that type of premarital agreement where you have Barry Bonds' wife completely waiving spousal support when she had very little. I think she had no assets of her own. Now you would see that there would probably be at least a predetermined payment going to her, or a formula, but there would not be a complete waiver of support in that case. Because at the end of the day, the clients want this agreement to be enforceable. They want to be able to rely on it. So we want it to be balanced. We want it to be able to withstand, any challenge. If one spouse, does decide to challenge it. And we want to incentivize someone to follow its provisions. And so these are the types of agreements you're going to be seeing for celebrities in their premarital agreements. We're not seeing the all or nothing agreements anymore. A lot of people also ask me, how do clients find attorneys to draft these? So it's interesting. There's family law attorneys that draft premarital agreements, and there's also estate planning attorneys that draft agreements. And I would say you want your client to have an attorney that regularly drafts these agreements, that is used to drafting them, not do. If they're a family law attorney, if they're a certified family law attorney, that's something you'd want to look for. But you definitely want to ask, or have your client ask, about the how many agreements the attorney has done and how familiar they are with these. These agreements, everyone that I do looks different from the last. They are very, very tailored to the specific clients involved. So, and I do them all myself. It's not really something that you can, that you can give to an associate to do. These, are crafted taking into consideration the client's specific assets, their needs. A lot of clients have a very strong view of what they think is fair, and trying to incorporate that into the agreement, while at the same time proposing provisions that the other side, will agree to. It is a negotiation. You have to expect there to be a few drafts. It would be unusual if there wasn't. On average, there's at least 3 or 4 drafts. I think the longest premarital agreement that I negotiated was that's rather unusual, but these can get really complicated. And unlike a lot of other, business contracts, there's a lot of emotion that comes into play with premarital agreements. and people's views on marriage, people's views on money, their family history with money, all of that comes up. It's a very interesting exercise that actually I think everyone should have to go through, whether they're a celebrity or not. And a lot of my clients tell me at the end of the process that they're really glad that they did it. They hope that they can put the agreement in a drawer and never look at it, but it forced them to have conversations, with their significant other that they ordinarily wouldn't have had, before they got married. So, I think a lot of clients find the exercise, although, no one's excited about having these tough conversations about divorce and death and money, they find it to, actually have been really constructive in terms of, going into this marriage, having tough conversations, knowing how one another feels about certain things. Again, not always easy, but I think actually very important and very, very helpful and very healthy for the relationship. Another thing that I will add about these agreements is kind of how they're negotiated. Most often, especially with high net worth clients and celebrity clients, you have most of the communication going through the two lawyers, lawyers trading draft of agreements and emails, about terms. There is also an alternative way to put these agreements together. I always offer it to clients, and I would say the majority don't opt in for it, but I think it's really interesting and it's at least good to know about. So before anyone starts drafting, the clients and their attorneys will meet, whether it's on a Zoom, and they'll have the conversation, basically kind of going through all the things that we discussed right now. This is what the default law is, these are different things that the agreement can do and not do. And it's a collaborative conversation between the clients facilitated by the two attorneys to go through these and kind of reach conclusions, together. It is an option. It's not as popular with clients as just kind of using the attorneys to negotiate these, but I do think it's a really interesting option. I'm always glad when a client elects to do it because I think it's great and it's interesting. But just so you know that your clients do have that option, can ask to do that if they want something where they can feel a little bit more involved in the process. I also wanted to talk about kind of who pays for the attorneys? This is a question that I get a lot, and it may seem a little counterintuitive, but the wealthier person should pay the attorney's fees for the less wealthy person. It does seem counterintuitive, but we want the less wealthy person to have been able to select whatever attorney he or she wants to retain, and we don't want money to have prohibited them from doing that. We want both people to have been able to equally choose an attorney that has experience doing these agreements. If challenged, we don't want the less wealthy spouse's representation to be questioned. So it is common, it's actually best practice in my opinion. I always have my client definitely pay for the attorney for the other person so that that's never an issue or it's never called into question that they didn't have great representation as well. So I did want to leave, some time if there are any questions that I can answer. I always think that that part of the program is most interesting. So I'm not sure if there's been any questions.
Yes, so we do have quite a few questions. Let's start off with this one. Could a celebrity's name, image, and likeness ever be considered a community asset or an asset with community interest?
So the answer is yes. Name, image, and likeness is definitely an asset, which means it can be characterized as community or separate. In my opinion, if you are already to a marriage, your name, image, and likeness has a value at the date of marriage. And then it has a value at the date of separation. And if that value increased over the duration of the marriage, the question would be, is that increased value community? Is there any, is there any, you know, is the reason for the increase, you know, that the celebrity, you know, client, you know, performed better at the Olympics that year, that they, you know, had a, you know, the most home runs that season, you know, was it because of things that happened during the marriage that increased their name, image, and likeness valuation? I mainly see that with professional athletes because in that sector, they tend to put valuation on name, image, and likeness, more so in other areas. But yes, that's definitely an asset, and it could be community.
The next question is regarding spousal support, what is considered gross disparity in incomes between the spouses?
You know, it's all relative, you know, but I think anything, any income that you have that, you know, isn't, is double, is going to be a disparity. Typically with high net worth and celebrity clients, we're looking at, you know, a gross disparity, meaning, you know, millions or hundreds of millions, and either no income coming in or, you know, insignificant. And that would be a gross disparity. So for instance, in the Barry Bonds case, you know, it was Barry Bonds, you know, with his, you know, baseball contracts and endorsements, earning millions and millions of dollars, and his wife was a hairdresser. So that is a gross disparity in income.
Right, and for the next question, how would you calculate what would be a fair lump payment in lieu of spousal support?
You know, this is probably one of the hardest things about these agreements, because most of the agreements that I am drafting do have this lump sum provision. It's always really tricky, right? Because this is pretty subjective. So we have to take into consideration what we're asking the other person to waive. Support.
Hi, Monica. We had a lapse in connection. Could you repeat the answer to that question in its entirety? It cut out for a bit.
Oh, sure. Oh, can you hear me?
Yes, I can hear you now.
Okay, so the lump sum provision is always a really tough one because it's very subjective. The amount is very subjective. If we're asking the less wealthy person to waive spousal support and we're not creating any community property, we have to make sure that that number, that lump sum number, is significant enough to offset all of the things that we're asking them to waive. So it's very difficult to come up with a number. There's no science to it. It's really an art. We also have to take into consideration the client's balance sheet because again, they have to have sufficient liquidity. It's got to be an amount that that we can ensure that they can pay. So it's balancing, trying to address all of the waivers and making up for that, while at the same time looking at the client's balance sheet and making sure it's an amount that we can be sure that they'll be able to pay. Yes, but it's very difficult to do, and there's no science to it at all.
All right, and the next question, have you seen prenups addressing pets in case of separation?
Yes, I have, and this has actually become more and more popular in the last few years, at least for me. But yes, you can address to your pet if the relationship ends. Everything from who, you know, one person's going to keep, you know, the dog or the cat, to a shared custody schedule. I had a client who they agreed in their premarital agreement. They had 2 cats. They pre-agreed on what the schedule would be if they divorced, and the cats would go back and forth to, you know, each of their homes. But yes, that's becoming pretty common to see.
All right. And with IVF becoming more and more popular, do you see this being handled in prenups, for example, frozen eggs and embryos, etc.?
Absolutely. So it's a question that I always ask my client. I have this sheet that I give them where I ask them, this is all the information I'm going to need you to compile for your asset disclosure. And I always have, you know, uh, frozen embryos on the list. We do have to make sure that we address them. So when you do freeze embryos at a clinic, they give you paperwork. And in that paperwork, that's usually, like a stack like this and a zillion questions, they do ask you what you want to do with the embryos in the event of a divorce. Most people don't even realize the question was asked and they don't even know what they put down. So we go back to the paperwork and we find out what they said when they filled out the document. And then we say, do you still want to do that, or do you guys want to agree on something else? And if you do, we have to include it in the premarital agreement. But yes, I ask everyone because it's very, very common for people genetic material now before marriage.
And circling back to Taylor's prenup, would you think there'd be any language regarding attorney's fees?
I'm sorry, regarding?
Attorney's fees.
Yes. Typically, there is a provision in premarital agreements that says that if the agreement's challenged, the prevailing party is awarded attorney's fees. And we put that provision in because, again, we're trying to deter people from challenging the agreement. And if they challenge and lose and they have to pay fees, it may discourage them from challenging the agreement.
Right. And then could the prenuptial address how the surviving spouse disposes of his or her assets in their will or trust when one spouse dies first?
Yes, there can definitely be a specific estate planning provision in the premarital agreement that says what the surviving receive. But remember, this is only a promise. After they get married, they're going to have to go and amend or create their estate plan to provide for whatever they promise. Marital agreement's not an estate plan itself, it's just a promise. In the event that someone actually didn't get around to creating or amending their estate plan, and then they pass away, the probate court would take into consideration, of course, the promise in the premarital agreement.
All right. And one final question. In your opinion, what would the best jurisdiction and venue be for Taylor Swift?
Well, I'm going to say California because, this is where I practice. I think that, well, she could probably, she has real estate and lives in various jurisdictions in various states. So she has some options. I think that California, we draft a lot of premarital agreements. I think we're really adept at handling high net worth and celebrity agreements. I think our attorneys, I would say California and New York, have a lot of experience in that. As you could tell, there's very special provisions and considerations when you're dealing with high net worth and celebrity clients. So, I think LA and New York.
All right. I just want to take a moment to thank you for your time today. This presentation was very thorough, and I want to thank our attendees for joining us this afternoon. I hope everyone has a great day.
Thank you.